and close board comments. As we proceed with this meeting, and I'll remind everyone at the next meeting as well, if we do open up comments and there are any comments, please make the comments and questions to the board. And from there, if we choose to have the staff answer any questions, we will direct it to the staff. So if there are any comments or questions during the meeting, please direct it to us as the board of directors. Please do not ask questions directly of Kevin, Aaron, the attorney. We want to be a little more formal here and do things the right way. We'll move on to the consent agenda to approve the agenda, our minutes from our September 4th meeting, bills paid, and writing off delinquent accounts.
I'd move to approve the consent agenda.
I'll second. We have a first and second, all in favor, and the motion carries. Item number 5 for discussion and possible action, consideration of the district's possible involvement or participation in the legal action known as the Mineral County and Walker Lake Working Group versus the Walker River Irrigation District, etc. I believe, are you going to start off on this, Kevin, or we go into both?
Okay, well,
Go ahead, please.
so, as the district received notice from one of the parties involved in the litigation, we received the back materials on, and has asked the district to get involved in some manner. Customarily, what the district would do most likely if it were to get involved is file an amicus brief, basically as a friend of the court, and basically offer input and suggestions on what the outcome should be on this issue and how these things would impact and affect the district. So this is it's a litigation matter. My preference is that there could be confidential, sensitive issues discussed related to this that might be appropriate for litigation session. Otherwise, certainly the board can weigh in on what the board members feel is important concerning these issues. Could this potentially impact the district and its rights? I think it could. I think a decision here from either the Supreme Court or even possibly the Ninth Circuit could very well impact the district's rights. The attorney who contacted the district feels that this essentially could wreak havoc on the whole prior appropriation structure that water law has followed in the state of Nevada since people started moving to the state of Nevada. So the district can be involved in a number of different ways. One way would be to prepare this amicus brief. Another way would be potentially to get involved with other water purveyors in the state, see what they're doing, and potentially make more of a collaborative effort on submitting a brief to the court, assuming our interests are aligned with them, which I imagine we will.
And can you give us a quick Cliff Notes version of what this case is all about? What's the gist of what we're dealing with?
Yeah, so this case, actually, this litigation goes back many, many, many years. But it really is a dispute over whether or not these permitted or certificated water rights can be changed. In other words, the state engineer and Division of Water Resources granted water rights to a particular party, and then another party has come in and is saying, under this public trust doctrine, that anytime there are navigable waterways or tributaries to a navigable waterway, if wildlife there or if use of those waterways is going to be impacted by additional use of water that would negatively impact the public's use of that public resource, that the public trust doctrine could be used. And this is somewhat unique to this case. Normally the public trust doctrine would be used in other cases involving other situations, but this is a little bit unique that they're trying to apply, or at least they're asking the court to apply the public trust doctrine to essentially replace and undermine the doctrine of prior appropriation, which I think is what the board is already familiar with. That's what you guys are familiar with it basically is first in time, first in right. Whoever puts water to beneficial use first has that right, and anybody else that comes along subsequent to that, can't use any water that would jeopardize the rights of the party that's prior in time. They're basically, one of the major things that they're doing is they're saying, okay, that's all fine and good, but that doesn't consider the public trust doctrine, this whole separate theory, this whole separate legal theory, which we think, should supersede, or that this whole prior appropriation should be subject to this public trust doctrine. That's really the question. In the event it's determined that the public trust doctrine can circumvent or supplement or replace this prior appropriation theory, then would the impact on these holders of these water rights amount to a taking of those water rights? In other words, if we say that these prior appropriation rights no longer exist or are somehow diminished by virtue of the public trust doctrine, do we then have to compensate these holders of these water rights, these parties that we said have these rights, under the constitutional doctrine of the taking, which is taking away a right that somebody holds, and then the Constitution required that they be given just compensation for whatever the value is of the right, of the right that was taken.
A question about that, if you don't mind, isn't that, does the state not have the power of eminent domain? Couldn't they take it, but then by taking it, so they could be taken by the state?
It could be taken by the state, yes. I think that's a somewhat different situation here where you've got, currently, to my knowledge, and we haven't dug into great depth here, we've just basically reviewed the information they've given us, and then, we're somewhat familiar with public trust doctrine generally. But yeah, I think the situation would be a little bit different in that these are privately held rights, that aren't being condemned or taken by a public entity, even though a court would be used. But in some sense, the analysis is similar. In a condemnation action, it would be just compensation given for that. So, yeah,
That's
not
part of-
exactly the same, but yes, very similar.
That's part of the
in some
system,
respects.
right?
It is, yeah.
Who pushed for that second question to be considered? Was it the water district, or was it Mineral County trying to say, if this happens, then you will be compensated? Who was pushing for that second one? I don't remember.
When I read it, the defendants were the ones who.
That's my understanding as well.
I mean, it makes sense. The other guy didn't want to be considered the other way. Okay.
Kevin? Have anything you'd like to add?
I agree with Bo, his assessment that, this underlying has the potential to change, state water law. And, I think, the district probably should enter, into this and support the water district up north. And also pursue seeking out the other districts, in the area that are also interested in participating also.
SNWA, or they?
Where they at on it?
So far, they haven't yet made a decision. Last I spoke with their attorney, Greg Walsh, they had not yet just made a decision as to what they were going to do.
Are they leaning in any particular direction that you're aware of?
No, no, they were trying to wrap their heads around the whole issue.
Are Mitch and Vic aware of this, or they, I mean, obviously it impacts them.
Yeah, my understanding is that they are. I haven't heard definitively back from them as to whether or not they were going to file an amendment group. Kevin, you have any information from there?
No.
I'll give you my 2 cents. I kind of agree with Bo and Kevin. I can see situations, however, where, there may be a higher purpose or need for the water. And at that time, I would definitely think that the government should compensate. I mean, take a look at our irrigation companies here. It took a lot of money, time, lives, blood, whatever you will, to put in the irrigation systems, have them washed out every other year, and keep developing the system to the point where they could be used to irrigate land. So, somebody come along and say, hey, you know, we don't think you should own the water rights, and I know a lot of that's changed, a lot of it's changed since then. Just let down the river to SNWA mostly now. Just come by and say, hey, you guys don't need that water, and everybody else should have a shot at it. I don't think it's fair either, so I agree that there should be some mechanism there to where if the state can prove that they absolutely need it and take that water, that the people should be compensated, the water should be returned when that need's no longer there. I mean, I could see in a severe drought or something, you know, last thing you want is some natural resource or state resource to be dried up and not used anymore, so. I'm not real familiar with the case. I read over the stuff we received as far as the letters from, the defendants and the defendant's attorney and, kind of the case a little bit. I kind of understand it, but I'd like to understand it a little more before I took that step forward and voted for an amicus brief, but I think that's where I'm headed, so.
I think we gotta research some of the other water companies around, Nevada and see kind of where we're at. Are we lining up? Are we getting all the proper information? Or, the documents are here, we have the letters like Rich was talking about. I mean, does it require a little more research to make sure we're on the right side of this? I think it does. I do think we have to protect ourselves at the very end. And I do think doing research would hurt.
So would we have a motion, or do we just direct staff to look into this further and get us some more information and let's bring it back and,
Is there a deadline on this? Is there something?
November 26th is the
So we
date.
have a little bit of time.
Yeah.
Well, I was thinking it'd be nice to have Thanksgiving dinner here and.
Yeah, so I think staff wanted to make sure that, there wasn't a bunch of money, time, effort put into this if without direction from the board as to, that you wanted that research done. Calls were made to other purveyors around the state as to what their views were of this, which we commonly do when issues like this come up. But extensive research into all of the background of this hasn't yet been done because, again, that would take a lot of time, effort, and.
Well, it sounds like we have time. I mean, I don't think it would hurt to at least reach out to SNWA and a few other, municipality water districts, find out, what's going on here. We have a little bit of time on our side, I think, versus just jumping right into it, as far as I can see anyway. I mean, even if we wait 30 days, 45 days, and maybe, some new information comes to light that we weren't aware of. I mean, at this point, reading the letters and stuff, I think it's a good thing, the brief, but at the same time, if we have a little bit of time, what's the hurry? I don't wanna vote for something that may, like Rich is kinda saying a little bit, let's make sure we have our ducks in a row before we jump in bed with them.
Yeah, let me maybe provide some insight on that. So, this isn't urgent.
Right.
I think it was just a matter of, hey, this was received, let's get it in
I'm
front of the board.
satisfied.
Let's get the board's view on this and see if there's interest in further pursuing this. So nobody that I'm aware of, is, pushing that this happen immediately or that, the district get heavily involved in this. I think, and this I think goes to the second point, Randy, that you made, and that is, the district would have full control, obviously, of whatever it puts in this amicus brief, if it drafts one. And that would simply be, I think, to preserve the district's rights, to make sure the district doesn't necessarily have to take a strong position as to the precise issues that are involved with Mineral County, for example, and the irrigation district there. But yes, as it relates to general issues that would impact the district would have full control submit something that said, we think our rights that we've, spent a lot of time acquiring, a lot of money, a lot of resources, a lot of background, going back into some of these, parties that initially came to the valley. I mean, a lot of investment is gone into this, and, to lose those rights would be devastating, and that, yes, in the event somehow this was done to essentially supplement or replace the doctrine of prior appropriation, I would think just compensation would be appropriate, in that situation.
I think a letter similar to what you're saying is basically stating our position. Obviously, we want to protect ourselves. Maybe not delve into what they're up against, but state our position, what we would like to preserve. I think it'd be more of a letter I'd be comfortable with. I don't wanna delve into their issues just yet if we don't have to, but I think you're right, state our position. Hey, this is where we're at, we put a lot of sweat equity into it, we have a lot of vast interest here, and I think something like that, I think would be a little more easy to swallow.
I think what I'd like to see is a little more research done, but also in the meantime, don't know how you figure it out, but, put together a budget of time and how much we're willing to spend on this, and then bring it back and take a look at it. I wanna protect our rights, and I think if, another water district's having issues and we don't do anything, one day we could wind up in the crosshairs, and we gotta protect our water and our rights out here.
Well, and that's one thing, I'd like, when we look at it again, I'd like to see kind of an outline of all the different areas where it's impacting us, so that we can really take into account all the places that we might not even be thinking about. Like for example, I mean, obviously this would impact our master plan, okay? Cause if we lose a bunch of our water rights, then, obviously we're making long-term plans, with what we have, and if we don't have that, then it entirely changes our master plan, right? But I wasn't thinking about all the historical costs and monetary investments that had been made before, and so that would be nice to be able to kind of see a list of all the different facets that this could be impacting that as it relates to our particular water district, because like you were saying, that should be the gist of what our brief should be if there is one. And I think that's what they're asking for anyway, so.
Any comments from the audience on this issue? Okay. So, do we make a motion, or we just direct staff to do a little more research and get back to us?
We definitely would want a motion in the event the board, decides that, a brief should be submitted, then absolutely that would require a motion. Whether or not I think we understand what the board is wanting, it would be fine to make the board member to move to direct staff to provide some further, to do some further research and provide some additional information based on the points that have been made by the board members tonight, and then bring us back before the board, with some of the details you included, with enough time that in the event the board does decide to have something submitted to the board, there's time to prepare that.
I'll make that motion. I move that we direct staff to go ahead and compile more information moving towards the amicus brief, and bringing this back at a later date to discuss.
Second that.
Okay. We have a motion on the table, all in favor? And the motion carries.
That included talking to other water districts and water companies.
And I did like did we get that in there as far as the budget and comparatively?
I think that.
All right, item number 6, for discussion and possible action, consideration to approve amended and updated design standards and specifications, and to ratify the action to remove the cross connection and backfill policy from the DSS so that not a lot of acronyms going on here. Feel like I'm at church or something. Okay, from the DSS so that the CCPB.
Well, at least it's not EDA.
Yeah, true, yeah, or it's, will no longer be contained within the DSS, but will stand as its own policy.
Would you read that again?
Sounds like a commercial for him.
Yeah, I'd rather, do Fuzzy Wuzzy was a bear.
Okay, at our last board meeting, we brought, the design standards and specifications to the board, for your consideration. At that meeting, you approved the cross-connection control and backflow, policy. And because in the language of the, agenda item, it did specifically call for it to be actually separated from the design standards and specification. That's why that piece is part of the, agenda item for tonight, is to actually ratify that piece of it. We also, started talking a little bit, started down the path, not very far, of going into the details of the, proposed changes. Travis at that meeting indicated he had, several concerns, with the design standards and specifications, and so the board voted to table the item until staff and Travis could get together and go through those, issues. A couple of days after the board meeting, staff and Travis were able to get together, and go through, I think, almost every one of the concerns that Travis had, and I think we, resolved, I don't know, I don't wanna say all, I'm not gonna put words in your mouth there, but I think we resolved, at least 99.9% of them, over the last week or so, and, so now we got it back before the board, for, discussion, approval, any other changes, that you would, see fit. So at the last meeting, I told you I had a PowerPoint put together, which was included as part of the packet, that kind of gave a synopsis by section of the changes, within the document, and, we could do that tonight, whatever the board would like to, however you wanna move forward on this, your decision.
First of all, I wanted to thank Kevin and staff for meeting Friday. We went through all of the document for about 2 hours, and we actually had really good conversation as far as I had a lot of questions, and staff had done a lot of homework on these issues as far as pipe, the whole range of the document. So it was a very good conversation, and I thank staff for all the hard work and that they put into it, really researching the issues and helping to put my mind at ease on some of the issues. And then there was some that they were, yeah, let's look at some of that. And so that was very, very helpful, and I think it did. We worked out all of the issues. I think the only thing that me and Kevin were talking about today was some of the standard drawings that needed to be still updated based off ours, but as far as the overall document, I felt very confident with what we have now. I mean, some of the issues, like I said, they bore with me on my engineering OCD on calling out section numbers instead of using Roman numerals, to go using regular numbers so that it's throughout the whole document, things like that. So, but then there was big issues with the PEX pipe and easements, and some very good conversations on why the staff or the district is going this way, and I felt very comfortable on that. Engineering decisions in the document as far as how to update the water models and things like that put in. So I think it's a good document. Just like anything else, I'm sure that there's going to be things in the future that come up that, just like anything else, but for right now, I feel very confident in what they presented and changed. So, in my opinion, I think that if we would like to look at his presentation, it doesn't hurt, but I'm very confident with what we have placed before us, so.
I'm sure it's a very riveting presentation, and I would love for the audience to have the opportunity to see the work that you've put in on this. So let's go. And Randy was asking he says he couldn't remember what happened last meeting, so he wants to see it.
If I remember correctly, Neve, I wasn't here last meeting. So that was a nice try, but.
Would you like to get a Diet Coke or anything
I'm good.
before we get started?
Yeah.
Okay, just,
Then you turn on the overhead lights and.
One minute?
no, you're good.
That's why I should have that seat back.
We'll keep that on next time agenda.
We're gonna wait for the light to warm up there.
That you were going the other way with that comment, that you weren't gonna want him, I was gonna tell you, hey, don't worry, you'll let him do his thing, man.